So my name is Ciara Cullen. I'm an IP and tech partner at RPC. I'm also head of the food and drink group. So this is the legal slot, and I'm pleased to see that that didn't turn off too many of you. So hopefully you're all well fed and well rested after lunch. So today I'm just going to very briefly talk to you about things you should be thinking about in terms of capturing and protecting your IP, and also just looking at a few ways in which you might be able to enforce your rights. Now, I've only got 20 minutes, and I'm conscious that it's a really diverse group in the audience, so I've kept this very high level. But if any of you have any questions, feel free to grab me on the next break and we'll have a chat. So if I was the founder of RPC Gin Distillery, that would be a rubbish brand for starters, but what type of IP rights or assets should I be aware of or thinking about? Well, there's actually a whole raft of stuff. Like there's the obvious one that we all think of is the brand name, which is obviously very important. And from an IP perspective, you want it to be something that's clear to use, as in it's not being used by others. And also something that you should be able to obtain trademark protection for in the jurisdictions in which you want to operate. So basically, in brief, you want to be able to ensure you can use it and you'll be able to register it as a trademark. And so very early on, when you're either setting up or you're bringing out a new product, you really should be thinking about the territories in which you're going to operate and whether you can get protection in those countries. At a minimum, you should be performing some preliminary trademark searches at the online registries. Like you could do that yourself, or what I would recommend is that you get a trademark agent to do a full clearance search for you. Obviously, it will involve an outlay or investment up front, but I think it's really well worth it to mitigate against the risk of dealing with a trademark infringement or passing off disputes somewhere down the line. So what else do we have then? When I look at the bottle, I think about the labels and the artwork that might be on the bottle, which could attract copyright protection. So the beauty of copyright is it's free. It's something that just subsists by law, and you don't have to pay for it. The test in terms of meeting copyright protection here in the UK is relatively low. So basically, you just need to make sure that you or whoever you've used to create your materials has not copied it, and that they've put some skill and effort and labour into creating the work. Like I said, you don't need to register anything, and if your work is an artistic work and it attracts copyright, that will allow you to stop any third parties from using that work, so basically copying it or ripping off your product. Then let's take a look at the bottle again. So the obvious thing here is the design of the bottle or the box. So there's various different IP rights that could arise in the bottle or the box. So unregistered design right basically protects the shape or configuration of the bottle, provided it's original and not commonplace. My rubbish example obviously would not attract protection because it definitely would be in the basic commonplace category of bottles. If, however, it is original, you would have the right to stop third parties copying the design of your bottle, and that's a right that can last for up to 10 or 15 years, depending upon when the product is made available. Similarly, you can also go and register a design at the UK IPO. Now, design right protection has the benefit over an unregistered right in that it gives you a monopoly. So basically, if someone else independently creates a bottle that looks like yours, you will be able to assert your design rights against them and stop them doing that. It's more like a patent, if you're familiar with that area of the law. Whereas with the unregistered right, you have to prove that they copied it, which is much harder. The additional benefit, obviously, with the registered design is it's something that you have for 25 years, but the downside is you need to pay money for it. You're going to be paying a filing fee and a renewal fee. But again, it's something that I think is worth being aware of. So that's kind of dealing with the bottle. Obviously, outside the bottle and the product itself, there are a whole raft of other IP rights to be aware of. So when I think about, potentially your recipe, if there's something unique in there, it's really important to make sure that you keep that confidential. So even when you're speaking to any third parties, and I would always say to clients of mine, even if it's investors, you're looking for extra money, make people sign an NDA. I know people are sometimes afraid to do that, particularly in the early days. They think it might look a bit arsey, but actually the people at the other side of the table you're dealing with will respect that and expect it, and it shows, I think, real professionalism and that you care about your product. And these are all things that you need to be able to show you're doing, further down the line, maybe when you're looking to sell the business or you're looking for investment from a bank or a third party. They'll want to know that this is the way that you've operated in terms of protecting your IP. Distillation process and techniques. Now, I'm conscious that this is something you guys in the audience will know a lot more about than me, but the point just to make is if there's something inventive in there, and I know the bar now is very high for patent protection, it basically needs to be new, like as in not done anywhere globally before the date you apply for the patent, and there needs to be an inventive element to it as well. But if there is something that you think is patentable, it's definitely worth looking into, because a patent is basically the crown jewels. It gives you a monopoly right. It also can create actually a nice, entirely different revenue stream, in that you could license that out to third parties to use that process as well. Then, of course, websites. I'm pretty sure everyone here in the room probably has one. There's a whole raft of IP rights potentially in there. The key when you're talking about your website is to make sure that any third parties, web developers, designers that you're using to create content for your website, that you get a written assignment from them which transfers all the IP rights they've created over to you and your company. All just good due diligence, and I'm sure this is something that I'd like to think most of you in the room probably take care of anyway. And then I suppose the other element where I see a lot of IP rights arising is around your advertising and marketing campaigns. Like, there's going to be a whole load of IP content created there. So the key again is when you're dealing with any agencies or third parties, make sure to get that written assignment of any IP rights they create over to you. And equally, the obvious thing, make sure if they're using any third party materials that they've obtained the right licenses for you. So just to recap before we get into the enforcement piece, a quick checklist of things to think about when you're either starting out with a new product or launching a new product in your portfolio. Make sure you clear your brand name. It's an obvious one, but I think people get very invested in a particular name and kind of start going down the road and get very attached to it before they've actually checked whether it's available. And it's much more difficult to kind of roll back at that stage when you've put money into it and also you're kind of emotionally invested in the brand. Register trademarks in relevant territories, as I already mentioned. And then just like smaller things like ensuring that you use your trademark symbols and copyright symbols to put third parties on notice of your rights. When it comes to your website and your terms and conditions, make sure that they have the appropriate terms in it around, IP ownership, and that people can't just copy content from the site. The big one is dealing with third parties, like I've mentioned a couple of times now, design agencies, consultants, like anyone outside your business who's not an employee, whether it's a contractor, consultant, or a third party. Make sure if they are creating any kind of content for you, whether it's to do with your branding or design of your bottle or content for your website, that they assign all the IP in that over to you and your business. We already touched on design registrations. Recipe, like I said, keep it confidential. Always use NDAs. Don't be afraid to do so. And then on the patent side, I suppose one point I should mention, if you do think there is something, and whether it's you're using, some kind of tech has been created or it's something to do with the process, the distillation process, make sure that you do not disclose that. The temptation that we all have when we come up with something innovative and cool is to stand up here in a room full of people like this and talk about it, or to write an article about it, or somehow disclose what it is because we want everyone to know. But that's actually going to undermine your ability to get a patent if you do that, because you'll have made what's called basically an enabling disclosure, and the Patent Office won't let your patent through. So Let's now look at dealing with infringers. So we have a situation where you've got your product, you're up and running, you know what your IP is, you've properly captured it, but you also need to then go and enforce those rights when people are using it in a way or trying to rip off your product in a way that they shouldn't be. So I thought what better way to look at this than actually go to an actual case that was in the High Court. Now it deals with champagne, this one, rather than gin, but obviously it's all the same principles that will apply. So this case is Champagne Louis Roederer and Jose Garcia Carrion, and I'm obviously now slightly anxious about who's sitting in the room. So the claimant in this case, Champagne Louis Roederer, are the owners of the well-known Cristal champagne brand. And the defendants are a big producer of sparkling wine, or cava, in Spain. They came out with a product called Cristalino, which is there on the right. And they were selling that. It was being imported into the UK and being sold in Asda and Morrison's for £5 a pop. And needless to say, Louis Roederer weren't too happy about that. So they brought trademark infringement proceedings in the UK High Court against JGC. And basically what they alleged was that your sign, Cristalino, is very similar to our trademark for Cristal. And so they had a EU and a UK trademark for the word Cristal in class 33. And they said it's very similar. They said it's the same products, you know, champagne, sparkling wine, cava, let's put them in the same category. And that it is very similar and it will cause confusion to the relevant consumers. They also said, we've got a great reputation in the UK, and what you're doing is basically free riding on that reputation, and also you're going to dilute our mark. So what did the judge say? It came before Miss Justice Rose, who agreed with Louis Roederer and said that, yes, indeed, the two marks are very similar. And so she looked at the marks not only from a visual, but also an oral and a conceptual perspective. And she said, visually, yes, they look the same. And what's important here and in this market is how would the customer be looking at it? And you have to bear in mind that the brand name is on the convex of a cylindrical bottle. And basically what the consumers are going to be really seeing is the first part of the word, which is the same in each case. So she put a lot of emphasis on that. Also, in terms of how it sounds, well, she said invariably people are going to be buying this and saying it in noisy environments, whether it's nightclubs or bars or restaurants. And I think what she said is the eno might just be lost at the end of the word. And then conceptually, I suppose the point is that when you say Cristal, it both sounds like crystal, basically, and it gives that same kind of allure of prestige and luxury and something precious. Now, you, like me, might rightly think, what member of the public is going to be confused into thinking that their £5 bottle of pop is coming from the same source as Cristal? But actually what the judge looked at, quite interestingly, in this case is indirect confusion and the risk of that. And what was particularly relevant was the practice of having a second wine, which a lot of the wine houses do, and they kind of bring out a more affordable alternative within their portfolio of products. And she said that actually, in her view, members of the public could be confused into thinking that this is something that, you know, the company behind Cristal had done. Then, in relation to the free riding, the claimant in the case, Louis Roederer, brought loads of evidence which they got from social media, which is quite helpful to their case, with people being online bragging about drinking Cristalino and saying, oh, look at me and my mates, we're drinking Cristal, ... I wish. And there was a lot of this type of stuff online. So that was very helpful because it was showing basically that there was a change in behaviour of the consumers of Cristalino. And then finally, the judge also agreed that it would dilute the prestige of the Cristal brand, basically, and it would turn off their target market and consumer if they thought that they were, basically, there were people out there buying this stuff and kind of for £5 a pop. So all in all, the judge held that, yes, this is trademark infringement. It was a really good result for brand owners, and they were entitled to get damages. They got their legal costs. They got a permanent injunction, and also and one point I should have mentioned, Cristalino had their own trademarks. They managed to get them invalidated as well. So that's just a kind of flavour of what a trademark infringement matter looks like before the courts. Now let's look at the online space and the online marketplace, which is actually where a lot more of the activity is happening nowadays, it goes without saying. The problem with the internet is that infringers and counterfeiters are basically near impossible sometimes to track down, and they tend to hide behind a myriad of offshore companies, and it's much more difficult to stop them from an infringement point of view. But there are other options now available to brand owners. In this well-known case, which I've referred to here, and the same principles would apply if it was you guys as brand owners bringing an action, it's L'Oreal and eBay. In that case, basically, the court held that it's now possible for a brand owner to get an injunction against the online marketplace where the infringing products are being sold. In this case, basically, users of eBay were being directed to infringing and counterfeit perfume and cosmetics and hair care products of L'Oreal's, and L'Oreal's weren't too happy, and so they brought an action directly against the individual infringers. So there was these individuals who were selling them, but you kind of know they're not going to be a good hit, and they're probably just going to start off and sell it somewhere else again. So what they really wanted to do was stop it at the source. And the importance of this case is that the court has held that you're entitled to get an injunction against the online marketplace, so whether it's an Amazon or an eBay where this stuff is being sold, if the marketplace provider, so eBay in this case, has played an active role in the promotion or the sale of the products. And by that I mean, I suppose, assisting with the advertising of those infringing products. Or if eBay, when you write to them, and so they've gained knowledge of the infringing activity, then fails to take the stuff down and act expeditiously. So that's another kind of very helpful thing, I think, to be aware of, and another way of going after and stopping infringement. And actually more recently now, there's the Cartier line of cases, which you may have heard about. So Richemont, who own Cartier, IWC and all those big luxury brands, brought cases against the ISPs here in the UK, so your BT and your Sky and so on. And basically the court has held that you can now get a blocking injunction, so you can stop the ISP from making those infringing websites that are selling your infringing goods, making them accessible. And so that's another really good way to stop infringers. And just something to be aware of. They're all just different tools to have in your armour. So I'm going to wrap up. I can see, I think that light has changed colour. So what do you do if you suspect that there is infringing activity? Well, investigate. You want to find out who is responsible for this, and also the scale of the infringing activity, like how much is being sold and where is it being sold. Now, ideally, and certainly my advice would be to hire a private investigator to do a full report for you. But equally, if that's not an option, given the nature or size of your business, there's an awful lot of information you can get online yourself by digging around and looking in Companies House and doing all those usual things. You also want to be collating your evidence, make a test purchase of the infringing product, and also gather any advertising and marketing materials or social media activity where they're offering to sell the infringing product, because you're going to need all this as evidence if you do want to pursue any type of legal recourse against an infringer. And then, you know, you really just need to consider your legal options and what your strategy is. So are you going to go directly after, whether it's the online marketplace, and, you know, issue a notice and takedown letter to them, or are you going to go directly after the infringing company if you can identify them and look for undertakings to stop the infringement under threat of proceedings? Or maybe actually you're going to go both and you're just going to do it all. Equally, you know, depending upon the scale of the infringement, if it's something really significant, you might want to go the ISP Cartier type route. Basically, there are lots of different options available to you. We've only looked at a few of them here. But I suppose I'd wrap up by saying that the key is that if you want to retain value in your IP, you should enforce your rights where appropriate and act quickly if you suspect that there is infringing activity. Thank you very much.